So good afternoon, Arizona Realtors. Thank you for joining us. We know these are challenging times for all of us, both personally and professionally, and I hope you and your families are doing well. You know, the Arizona Realtors, our goal and our focus is the health and safety of our realtor community. And we continue to monitor this COVID-19 situation and its impact on the health and safety of our members as well as the real estate industry. I want to remind you that we continue to put together resources for your use, the COVID addendum, the model certification form for property access, guidelines for open houses, economic impact information from economist Lawrence Young. If you were able to see that last Friday, if not, it's recorded and you'll be able to find that on our website. And of course, our legal hotline, which can be accessed by brokers and managers, continues to be available for transactional issues and the specific issues that we're seeing with COVID-19. However, we did realize that COVID-19 does pose unique financial challenges to realtors all across Arizona. So in response, we developed the Arizona Realtors COVID-19 relief hotline for all of our members, and it's answered by our legal hotline attorneys at the law firm of Manning and Cass, led by our own Richard Mack. So Rick was my law partner for 8 years before I came in-house at the Arizona Realtors. I can't say enough about him. He's a State Bar of Arizona certified real estate specialist. He's a member of Arizona's finest lawyers. He graduated with his law degree from the U of A. He has defended professionals in more than 1,000 civil litigations in every county in the state of Arizona. And I am so proud that he continues to be a resource and attorney for the Arizona Realtors, and I'm proud to call him my friend. So Rick is here today to talk about COVID-19 issues. Some of the issues that he's seeing on the hotline, some transactional issues, and any questions that you might have. So Rick, thank you so much for doing this for all of us, and I will turn this over to you.
Thanks, Michelle. Tatiana, am I good to go?
Yes, you are.
Good, okay. There are multiple issues that have come about because of this COVID-19 pandemic. What I've learned more acutely than anything in the last 6 weeks is that people react to crises and challenges much differently. Nobody's right, nobody's wrong, it's just different. What I would like to say from the very beginning is show some grace, show some patience. We're in this together. Nobody is out to hurt you. Nobody's out to take advantage, at least for the most part. Be patient. You can work through this system. We will get back to business as somewhat usual someday. I don't know when, but someday. But in the meantime, again, show some grace. And primarily with these governmental benefits, you have to be patient. It's not going to happen overnight. With that said, we got literally dozens of questions about what sort of issues realtors were facing. They can really be lumped into two separate categories. One is relief. I hear about these trillions of dollars. Are any of those available to me as a real estate licensee in Arizona? The second issue is dealing with contract relationships, landlord-tenant relationships, those type of practice issues. What about an open house? What about a showing? How do I make sure that everybody's on the same page? So what I'm going to do is talk about both of those issues in turn. I'm going to start with economic issues, survival. I think the most important thing for all of us at this point in time is to make sure we have an air conditioner on and groceries on the table. Some of you are in worse shape than others, but I think it's important that all of us understand exactly what is available to you as a licensee. So what I'm going to start with is, again, the financial assistance. And there are really two sort of avenues you can pursue. One is unemployment benefits, and I'll talk about that in a minute. And the other one is what everybody's calling a PPP, Payroll Protection Plan. It's an SBA loan that's forgiven under certain circumstances that you can get as part of the CARES Act. Both of those are available to you under certain circumstances. Both of those can be pursued by you. There is a decision you're going to have to make somewhere down the line about which you accept, because you can't really have both at the same time, and we'll talk about that and the why. But right now, you may pursue both at the same time, and hopefully you get both and are making that hard decision, which path do I want to take? So let me start with unemployment first. First of all, are you eligible for unemployment? And setting aside the independent contractor, W-2 wage earner sort of analysis for now, are you eligible? If you look at the Department of Economic Security website, that's the folks that administer the unemployment benefits. They have a COVID-19 section. They have a COVID-19 question and answer, and they talk about who is eligible and who is not. Effectively, if your business has been drastically reduced, they use that language, drastically reduced, because of the pandemic, you might be eligible. They give some examples of what drastically reduced could look like. Number one, if you yourself are sick or quarantined, can't work. If you're caring for a family member who's sick or quarantined, also can't work. If you're in a health risk, diabetes, lung problems, older, whatever sort of diagnosis or health risk you might have, that's also a reason recognized by DES that you might not be able to work and you might be eligible for the unemployment benefits. And then there's a fourth category. It's kind of a catch-all, any other COVID-related issue that separates you from your business. And that's what's happening to most of us is you're not getting new listings, you're not getting new buyers. Everybody's holed up in their house like it's like a cave, so they're not out doing business. So that language gives you the ability to attempt to qualify for the unemployment benefits. So once you get through that sort of threshold, then the question becomes, hey, wait a minute, I'm a 1099 person. I don't have W-2 wages, therefore I'm probably not eligible for benefits. That is traditionally the way our unemployment benefits worked. It's called unemployment insurance compensation, and the idea is, as a W-2 wage earner, you pay money in. You pay money in with each paycheck. Then when you are in fact unemployed, then you get some of that money back out. It's kind of a pooling of resources and sharing. For the most part, licensees are not W-2 wage earners. So for the most part, they are not entitled to traditional state unemployment benefits. There's a subsection of folks that actually pay themselves W-2 wages I'll talk about in a minute, but for the most part, you're not going to get the state benefits through DES. So the question we've gotten on the COVID hotline literally dozens of times in the last week is, if I'm not going to get it, why do I apply? There is a reason. You should apply. The way it's structured right now, the federal unemployment pandemic unemployment assistance program is tapped into through your state. So to get to the federal unemployment benefits as an independent contractor like you, most of you are, you have to first go through the state. More than likely, you're going to be denied. Once you're denied, then you're eligible for the federal funds. And I'll get to that in a minute. I want to talk about a little bit more of the mechanics of the state application process first. Bear in mind what this thing is designed for. It's designed for W-2 wage earners who are unemployed. That's not us. The questions on the application, to a large degree, are going to be really awkward for you. You're not going to have W-2 income. You're not going to have a base wage. You're going to have all these questions that aren't really going to fit. It's like a round hole, square peg sort of thing. However, answer the questions anyway. Do the best you can. And again, you can access this on the DES website, Arizona Department of Economic Security. Answer it the best you can and submit the application. A couple things to remember when you submit the application. Your brokerage firm is not your employer. You are self-employed. You're licensed with the brokerage firm, but you're an independent contractor. You are not an employee of your brokerage firm, so do not put that in your form. We've had multiple people call on the COVID hotline that have done it wrong, and once you've kind of started the process that way, it's really hard to unwind. I've heard of a couple agents who were able to wait online with DES, get a live person on the phone and have them correct it, or at least eliminate the application so you can start over. But the short answer is, if you haven't done your unemployment application yet, then make sure when you do, your broker is not your employer. You are your own employer. Related to that, brokers, when you get those questionnaires from DES saying, hey, is John Q. Smith an employee of your brokerage firm? You need to respond. You need to respond and say, no, they are not. They're independent contractors. Because if you don't deal with that up front, it's going to go against your unemployment record with DES. So everybody needs to keep in mind, we're not employees, we're not employers for the most part for DES purposes. I talked about an outlier, or some people that are in fact getting unemployment benefits, and those are the people that structured their business so they held their corporation or held their license in a corporation, collected their commission in the corporation, and then through that corporation paid themselves personally W-2 wages. If you handle your payroll or your compensation that way, then yes, you are going to be eligible for unemployment benefits. And remember there, your PC is the employer, you individually are the employee. We've had several, half a dozen or more agents who've structured their business that way on the advice of a CPA. It actually works in this in this situation because you would in fact be entitled to benefits. So all that said, you go through the process, you're the 99% out there that don't have W-2 wages, you're going to be denied. What next? How do I get a hold of the federal money? I hear about all these trillions of dollars. I hear NAR saying that there's money available for licensees who are struggling. How do you get there? You need to file something new for the federal benefits. As of right now, that answer is no. As of right now, the process is you get denied by the state, and then when the federal funds become available to the state, then you can get those federal funds. The timeline, May 12th of this year, is when we understand DES is going to have the ability to get those funds from the federal coffers to the state coffers and then to you. May 12th seems like a really long time. We've been living in this twilight zone for 6 weeks. By the time May 12th gets here, it's going to be 8 weeks. Why on earth did it take so long? I've heard agents in other states are getting their money right now. Remember, I started, have some grace, be patient. Here's the story with DES. They have, last I knew, nearly 100,000 applications, which is exponentially more than what they typically have. They have employees that have to process those applications. Those employees, like the rest of us, are dealing with their own fears of getting sick, the fears of their family getting sick. What's going to happen with the economy? Do they have a job? What's going on? Oh my gosh, when is this going to end? So they're used to dealing with a small fraction of what they have right now. They, like all of us, are under horrible circumstances because this is unprecedented and really difficult times. And they, like the rest of us, are doing their best trying to muddle through this stuff. So yes, it takes time. The DES folks hired a vendor who's working on a program that's somehow going to take your expired or your denied state applications, tap those into the federal funds, and then you start getting the money. Let's talk about that, May 12th, what's going to happen? The federal funds, the federal unemployment funds, Pandemic Unemployment Assistance Program, PUA. This thing's an alphabet soup like all of us. Everything realtors do is an alphabet soup. Now the feds have done the same thing. The benefits are going to be $600 per week. Those benefits are going to run, assuming you're unemployed, from March 27th till July 31st. Significant amount of time. $600 for, what is that, 10 weeks, 12 weeks? 12 weeks. In addition, there are other federal unemployment benefits available. The number is much smaller, and I'm not sure. I don't think anybody's really sure yet what those numbers look like or how you get there. But the PUA, Pandemic Unemployment Assistance Program, should be available to you beginning May 12th, assuming you've jumped through the hoops with DES. So, knock on wood, May 12th comes and goes, and a lot of you are able to receive unemployment, finally. As Michelle mentioned, we're running this COVID hotline. We've been doing it for a week and a half now, I think. First day we had 100 calls. We could only get to like 70 of them because there wasn't enough time. We're now down to manageable. We're getting 30, 20 a day, so we can take the calls. On those calls, common questions we're getting related to unemployment assistance, other than what I just went through. First, is unemployment assistance taxable? The answer is yes. It's a replacement for your wage. It's therefore taxable. So it's not a tax-free $600 per month. That money is in fact taxable both at state and national level. The second question we're getting is, what about me earning commissions? What about me closing 15 deals in the month of April? Am I still going to get benefits? If you close 15 deals in the month of April, and that's presumably what you typically do, you're more than likely not going to get through the showing that the COVID stuff has affected your livelihood. So don't apply if you're making your normal money. You shouldn't apply. There are people that really need the money, so don't apply. But what if you're going to just earn one commission or two commission or three? The strategy there and what you do is really up to you and your CPA. But the short answer is, if you're working and earning commissions, it's going to be a little difficult to say on that application that you are truly unemployed. If you're wrapping up one deal that's going to close last week, and now you don't have anything in the pipeline for the next 6 months or 3 months or whatever, yeah, you're probably qualified. But again, that's a judgment call you have to make. That's something you have to decide based on your sort of personal moral compass. Bear in mind when you're thinking about this, there are people really in dire need. If you're not in dire need, you might want to think about not applying, but you can. You're eligible, you can do it. So that is unemployment in a nutshell. More than likely, no state benefits, hopefully federal benefits beginning May 12th. Be patient, jump through the hoops, do what you need to do, and it is going to be incredibly frustrating. We've had many callers on the hotline who have just been really unhappy with the process. I get it, but everybody's doing the best they can. So again, take a deep breath, be patient. Before I move on to the CARES Act, do we want to take any questions now, Michelle, or do you want me to just keep going? I'm going to keep going.
Rick, you did have a question that asks about if they collect a commission while receiving unemployment benefits, does that affect your employment benefits?
At the state level, yes. They're going to ask you about income received with their questionnaires, and if you do in fact receive income, you need to report that. You need to be honest. And that is very likely going to affect, i.e. diminish or decrease the unemployment benefits you're entitled to.
And you have another question about if someone put their brokerage as their employer, should they go in and correct their application?
Yes, if you can get access still Yes, go in and change it. Your broker is not your employer. I've heard mixed bags about what you can really do with an application that's been submitted. But if you still have access and can change it online, by all means do so. If you don't, call the DES and plan on waiting on hold for several hours and see if they can do it for you electronically, or at a minimum, wipe out your initial application so you can start over.
And one last question on this. Do they need to keep applying every week and check in every week, or wait till the 12th?
Loaded question. You need to there's a questionnaire you're supposed to fill out every Sunday with the state DES. Do that. You don't need to reapply, but you do need to provide them the data that they request every week. Eventually, they're going to get the point where they deny your application, and you want it to be denied because you're not eligible, not because you didn't pursue it to the end. So every time you get something from DES, send it back to them, filled out to the best of your ability, as close to reality as you possibly can. So no reapply, but yes, answer the questionnaire every week. And I just saw another question on the screen. I do want to touch on this too. Retroactive application for the PUA, Pandemic Unemployment Assistance. The PUA came into effect March 27 of 2020. The money you receive should be retroactively applied, assuming you were unemployed as of March 27. So if you're still closing deals, no. But if you have been unemployed since March 27, the federal money should be retroactive. So your first check should be substantial. Then it's going to diminish to the $600 a month, or a week. I'm sorry, a week.
And we do have a few questions, Rick, just based off of everything you've already said. Did you want to go ahead and address the questions now, or did you want to hold off till the end?
If they're unemployment related, might as well do them now. If you want to jump into yeah, let's do a few more unemployment, then I'll jump into the CARES Act if that's okay.
Okay, let me see what we have first. I don't know if we already asked this, but just in case, if we collect commission while receiving unemployment, how does that affect all of this?
You need to report the income to the Arizona Department of Economic Security, and it will very likely diminish the benefits you receive.
Okay. Next question, if we have an application already, will we have to reapply on the 12th?
The best information we have right now, that answer is no. You should, once you've been through the process and been denied, that should require no further application for the federal money.
We are a PLLC with the W-2. If the corporation is paid, but your commission is not paid due to the payment structure at the end of the quarter, does that affect unemployment benefits?
Yeah, I think I know what you're saying. I'll try to deal with this quickly because this is an outlier that doesn't really apply to most people. A lot of people pay their PLC because that's where the license held. Then they pay themselves a quarterly paycheck to themselves. So the PLC pays the individual once every quarter. This is one of those moral compass things. If there's money in your PLC that you solely own and control, and you are choosing, I hear the airplanes going by the way. We scheduled this in competition with the Armed Forces flyover, which is really cool. If your money is sitting in your PLC and you're not paying yourself to continue to suck down those unemployment benefits, that's going to be a moral dilemma for a lot of people. If that's what you do, you pay yourself quarterly, and that's the way it's been for years and years and years and years and years, and you're comfortable doing that, yeah, you're okay. So you can report to DES, I individually received no money. My corporation has $50,000 sitting in it, but I'm not paying myself, so I'll pay myself to the end of the quarter. But you could honestly answer the DES questions, no income in that situation. Again, a bit of a moral dilemma. Not sure that's the best practice, but based on the way these things are written and drafted, yes, you can do it that way.
All right, so we'll finish up the rest of the questions toward the end so we have enough time to address everything that you still have on your agenda.
Perfect. Yeah, we're supposed to be done. I'm going to talk faster now. The CARES Act is the next thing. This is where this bazillions of dollars coming from. It's actually trillions. And the first question we get is, can you apply for both? Yes, you can. As we've been talking, though, receipt of PPP money is very likely going to temper your ability to get unemployment benefits. And I'll give you the big picture first. PPP, Payroll Protection Plan, that's money loaned to businesses so they can pay their employees. If you, as a self-employed real estate licensee, are the employee getting paid, you're gonna have to tell the unemployment folks you got paid. So it's gonna diminish your ability to collect unemployment. Depends on the timing, depends on your moral compass. The short answer is you're going to have to, at some point in time, choose one or the other, or at least adjust the timing so that the PPP money is paid through before you apply for the unemployment benefits. So let me talk about this one. And here's the good news. We had multiple callers this morning on the COVID hotline that received their federal money today. I don't know if that's coincidence that they all got it today, but literally it was half a dozen or so that received money today, and we're talking about what to do with it, how do you make sure that the loan is forgiven. But let me talk about this process as well. First of all, under the CARES Act, the Payroll Protection Program, it's effectively an SBA loan. Several threshold issues you have to meet, and this is a congressional thing, nothing that anybody in the state or NAR can control. You have to have a business account. If you only have a personal account with the bank, you're not going to be identified as a business and you're not going to be eligible. It's almost just an automatic kick out. So if you have a business banking account and a business relationship, you can apply. There's also a different sort of shoot-off loan called EIDL, Economic Injury Disaster Loan. That's typically $1,000 per employee. You do them all together with one package, and I'll get to that. How do you apply? What do? You go to your bank. Any chartered bank that is authorized to do an SBA loan can help you with the CARES Act PPP loan. They have applications. Their bankers know what is going on. Hopefully you have a responsive banker that can actually help you with the process. You apply for the loan through your business bank. It's a loan application. You have to give them income and expense statements. You have to give them some tax information. It's a loan. So you have to jump through those hoops. Then you submit your application, you get in line, and hopefully you're able to receive the money. As you know, the first round of funding expired pretty quickly. We're now in the second round of funding. Hopefully that will last longer, but at this point it's all fluid in the battlefield. I'm not sure anybody really knows. So get that application on file if you qualify, if you have a business account and are actually a self-employed person, so licensee with a business account, whether you have employees or not, you are both the employer and the employee. So yes, you have one employee. If you're self-employed, you have one employee, and that's you. What's it look like? What do you get? Typically, the PPP is an average of your payroll expenses for the last 12 months. So say your payroll is $10,000 a month on average for all of 2019. You get the average of your payroll expenses times 2.5. So on our $10,000 average payroll, you would get a $25,000 SBA PPP loan. Once you get the money, do you have to pay it back? That's the real question. They call them loans. However, that's a little bit of a misnomer. If you do some very simple things, the loans are forgiven. So it's really more like a grant. It's not a loan, it's a grant. What do you have to do? You have to use at least 75% of the loan proceeds for payroll expenses. It can be more than 75%. It has to be at least 75%. So in a sole proprietor situation, what's the payroll expense? It's you. You pay yourself. You pay yourself at least 75% of the money you receive over the next 60 days. That 75% is forgiven. If you pay yourself 100% of the amount over the next 60 days, 100% of the loan is forgiven. You can also use that other 25%, that delta, to pay other expenses, rent, mortgage, utilities, those sort of things. So if you don't have a huge rent obligation as a licensee, or you don't have a huge mortgage for your business as a licensee, the best practice is pay all the money to yourself, provide the bank proof that you did in fact pay all the money to yourself as your own employee, and the loan will be forgiven. It's kind of a fascinating way to make this thing work. They call them loans. You do a loan application. But again, if you use the funds for the specified purpose, the loan does not have to be paid back. A couple resources here. If you look at the U.S. Chamber of Commerce website, and also the SBA, the Small Business Administration website, there is a ton of information there. And if you're serious about doing this, it's going to take some time. I mean, plan on spending several hours reading and understanding and drafting the application. But there are resources available if you just slow down and read them and take care of it. Submit your application, and hopefully by the time your application is processed, the money is still there. So that's really the summary from 30,000 feet of the CARES Act and licensees. Any questions on that one?
Yes, we have a few questions. Let me see here. So the first one says, I understood PPP as a cap of 100K per year, i.e. no more than $8,334.34 per month. Can you advise if this parameter changed or clarify how this can occur? The example provided of 10K per month would exceed such.
If you're a single employee business, you can't have received more than $100,000 a year before. So there is a cap. The PPP benefits cannot be paid to folks who make more than $100,000 a year. So the point is well taken. If you're going to, if it's a single person business, I should have been more clear, single person business, your payroll expense has to be under $83.33 per month, or $10,000 divided by 12. So in that scenario, the most you could get as a sole proprietor and a business owner would be 100,000, they call it 99,999 divided by 12 times 2.5. That has not changed. That's a very good question, in fact.
All right. The next question is, I am a 1099 sole pro and have a business account that I deposit all commission checks in. Every month I transfer about the same amount of money to run my household. Is it true that this would be considered payroll?
The question, yeah, if you are paying yourself from a business account to your personal account, even though you're not doing it by way of W-2 wages, yes, you would be able to apply for the SBA loan through that. Again, talk with your banker. All this stuff is super fact intensive, but based on what that person just said, yeah, they can apply.
It says, once we are denied state unemployment benefits, do we still need to file weekly claims from state?
Yes. You need to get everything DES gives you, you need to fill out and submit back to them. And remember, the reason for that is you want your state denial to be based on ineligibility, not on you failing to process the application. So anything they give you, fill it out, sign it, send it back.
Okay. I think we have a few questions from Facebook, so let me see here.
Let's see. Okay, Rick. I have a tenant in a condo that is being listed for rental. The tenant says they are high risk and wants no showings until the lease ends on July 1st.
That's the next topic. The CARES Act, because what I'm going to get into next is practice issues.
Nope, doesn't look like it, not on Facebook.
Okay. Well, let's talk about the how this COVID stuff affects your practice of real estate. And I will get to the landlord-tenant issue in a minute, but I think there's some more. Well, let's just talk about that right now. The question, as I understand it, is a tenant says they're at high risk. Tenant says, landlord, you may not show this property because I'm at high risk and I don't want people traipsing through. Does the landlord have to respect that? I started this with show some grace at the beginning, and I'm going to continue to echo that. Yeah, yes, the tenant has to allow reasonable access within 48 hours. If the tenant is legitimately at high risk and has a concern, as a landlord, do you really want to put that person at risk? And as a landlord or an attorney, are you really going to go to court and force this tenant to let people in the house if he's truly fearful for his life? Be patient is my recommendation. Have your landlord talk to their counsel. But if those folks came to me, I would tell the owner, you know what, sit tight. You're going to have to wait. And let me jump into the rest of the contract issues or the practice issues just real quickly. I'm talking too much and I apologize. Contract. Let's talk about the standard residential contract. Just for context, we talked about the benefits. We're done with that, except I still see a few questions popping up. Done with the benefits. Now going to talk about how does this stuff affect my ability to practice real estate. Several things we're seeing. These are common questions throughout, and I just want to hit them as quickly as I can. They're fairly simple, some more difficult than others, but they're fairly simple. First question that I want to address, is the COVID-19 pandemic an excuse for either party, buyer, seller, not to perform? Generally, that answer is no. It's possible to close escrow. Licensees are open. Title companies are open. Banks are open. The recorder's office is open. Attorneys are open. Everything the parties need to close an escrow is available to them. This idea that they can't because of COVID-19 is not going to give them a legal excuse. A buyer, and we've seen lots of earnest money disputes when buyers just don't want to close. A buyer may choose not to. Flip side is a seller may choose not to. However, in making that decision, there are certain legal ramifications that come with that, like claims for breach of contract, claims for the earnest money, on and on and on. So COVID in and of itself, as of today, May 1st, until things change, is not an excuse. You may close, buyer may close, seller may close. There's no legal justification for failing to close just because of COVID. Might sound harsh, but that's the way it is so far. Lots of people are deciding to back out of deals, and lots of people are splitting earnest money, waiving earnest money, doing whatever they want to do. But from a legal perspective, generally speaking, no. There is an exception, like everything. If the buyers really can't get financing, if the buyers both worked in the restaurant industry or the movie theater industry or the gym industry or whatever and have no income, they're probably going to get a loan denial. And under those circumstances, yeah, not COVID itself being an excuse, but the consequences from COVID, i.e. I lost my job, yeah, that's going to allow the buyer to cancel. So the financing contingency still applies. The other thing that I hope you're doing, there's a COVID-19 addendum that adjusts timeframes. If we are delayed for whatever reason related to COVID, we buyer and seller agree that the timeframes are going to be extended by 10 days, 30 days, whatever you can pick. But there's a form out there, it's COVID-19 addendum, that you can address. Nobody has to sign it, and you certainly can't force the other side to sign it at the end when you don't really want to close because you're afraid. But if everybody is forward thinking, you sign that at the beginning, that's a nice way to deal with the uncertainty of what's going to happen next. You can use that COVID-19 addendum. So that is the contract in a nutshell. I want to turn on to landlord-tenant issues right now, unless someone has more questions about the contract itself or a contract issue itself.
Let me see. We have more questions from the previous topics, but we don't have any questions over what you just covered, so we can hold off until the end with those.
I'll blow through this, and then we can go back and deal with the assistance. I dealt with the assistance first because survival is foremost, so let me kind of blow through this and we'll get back. Landlord-tenant issues, just briefly, this applies in the residential and commercial context. Governor Ducey has entered executive orders that say there are going to be no evictions, no commercial evictions, no residential evictions, just no evictions. Does that mean all lease obligations are forgiven and go away? No, it doesn't. All it means is that the remedy typically available to the landlord for kicking you out for not paying is not available. Not available for now. It will become available again. So if you're a tenant especially, this pandemic and these executive orders are not an excuse to not pay your rent. You still must pay your rent. If and when, not when, when or not if, when the orders are lifted, and by then if you're 2, 3, 4 months behind on your rent, it's going to be really ugly and really hard to catch up, because once the landlords have the remedy of eviction available to them again, I promise you there's going to be a rush to the courthouse, and everybody that ignored their rent for the last 3 months is going to have a real hard time. There's going to be a day of reckoning with that. So if you can, as a residential tenant or a licensee representing a residential tenant, they need to either pay or strike some deal with their landlord to pay or defer or something with the rent, so it's not Armageddon when forcible detainers are allowed again. Second piece we've been dealing, one more about that. Even though there's no remedy of forcible detainer eviction, when the lease is over, the tenant has to leave. They're contractually obligated to leave. They can't just stick around and say, hey, well, the governor said we don't have to do anything and you can't kick me out. I'm not leaving. That's not what it's intended to do. Landlords, tenants still need to comply with the terms of the lease. If you don't, again, once the order's lifted, it's going to be kind of ugly for you. So don't use this pandemic as an excuse to behave irrationally or greedily. Again, show some grace. Commercial brokers, especially, a lot of brokers have commercial leases. Force majeure sometimes will allow you. Force majeure mean an act of God that says you don't have to pay rent or don't have to perform under the contract. If you're a commercial broker and your sales and therefore income have dropped, which I'm sure that's a very common thing, look at your lease. See if you have force majeure language in there. Oftentimes it will say, in the event of an act of God or a governmental mandated shutdown or all obligations under the contract are stayed or held in abeyance. If you have good language, you might be able to strike a deal with your landlord or make your landlord understand you don't have to pay. Unfortunately, a lot of these leases say they go through what force majeure is and they say performance is excused. But then there's a last sentence that says, notwithstanding the foregoing, an event of force majeure shall not have any impact on tenant's obligation to pay rent. So if you got that, you got to pay. So what do you do? What do you do when your income is down by 75% and you're struggling to make payroll and the copier lease and the IT payment and you got rent coming up as well? A lot of landlords, in fact, virtually all of them that I have dealt with, and it's been dozens already, are pretty decent. They will sometimes, I've had landlords forgive or abate rent for a couple months because they like the relationship. They want you to survive and come out whole on the other side. So they just said, okay, fine, time out, we don't have to pay. I've also had landlords say, I will forgive your rent, but you got to pay me common area expenses. That's also not bad. I've had landlords say, I will hold your rent in abeyance for 3 months. And then you're going to catch up over the course of the next 12 months, 24 months, term of the lease, whatever. So what you have is 3 months rent that's not paid, added on to the lease term, then amortized over the end of it. So there are all sorts of options available, but brokers, commercial tenancies, like the residential tenancies, you cannot bury your head in the sand, because when this order, the order is set to expire May 31, the order against commercial evictions, when the order expires, landlords that have been paid in 2-3 months are going to be heaping mad. And trust me, you don't want to be on the wrong side of a failure to pay rent eviction process, because you're going to lose. You have to pay. You don't pay, you're going to lose. You're going to have to pay late fees and attorney's fees and that. So cut a deal if you can so you don't get to that economic sort of disaster. Last thing on the practice side I want to talk about, actually I've got two things. I want to talk about showings and open houses, and I want to talk about disclosure. So I'll blow through these quickly. First of all, open houses. Should you have an open house? We've got orders that say you can't have more than 10 people together at once. If you have an active open house, you're going to have 10 people. If it's my brokerage firm, and again, you may, don't get me wrong, I'm not preaching here, but if it's my brokerage firm, I'm saying, you know what, let's hold off on open houses for a bit. If your sellers are adamant, okay, then here's what you got to do. And if you look at AAR Online, they've got an article about what you should do for an open house. And the first one is make sure you talk to your seller. Make sure they're aware of the risks. Make sure they know they're potentially putting themselves in danger. Not in the article, but I would also get some sort of signed acknowledgement. We understand COVID is a real thing, even if they're one of those guys down there protesting saying open it all up. Get them to sign, yeah, this is killing people. Not all of us, small percentage, but it's a real thing. We understand, we still want you, licensee, to proceed with your open house. You get that taken care of, then what are you going to do? Most of it's common sense. Nice idea. All the doors, open them so people don't have to touch doorknobs. All the lights, turn them on so people don't have to look at light switches. Have sanitizer, disinfect before and after. Open the windows so there's ventilation. Again, look at AAR Online. They will give you some really nice common sense tips about what to do about an open house. But my take is this, our numbers are at 7,500, give or take. They're growing pretty steadily, slow but steady. Do what you can to not spread it. Unless your seller's absolutely adamant, or you as a licensee are absolutely adamant, I think open houses, and this is my personal opinion, I own that, I think open houses are probably not the most responsible thing to do on a social level. Be socially responsible. Think real hard about open houses. What about showings? The next piece. Let's take it down. We only have one family going through. Same idea. Common sense with the lights and the doorknobs and the disinfectant and the open windows, etc. Make sure both buyers and seller are aware of the potential risks. If you can get something in writing from both buyers and sellers. I know several brokerage firms out there have created little one-page hold harmless and release documents so that everybody signs off. We know there's risk, but we don't proceed anyway. Do that, and then be respectful. Keep your distance. Don't shake hands. Do everything you've been hearing on the news and take care of it that way. The showings are much more single family, single group showings are a much more responsible way to deal with this than the open houses. So showings, again, be careful. I'm candidly shocked at the level of closings we're still having. So kudos to you, and I assume you're doing it safely. Continue with that. And again, someday soon we'll get back to close to business as usual. Finally, I've had this debate with several brokers, and the question is disclosure. Last topic, then we'll go back to assistance. Disclosure. If the seller is diagnosed with COVID-19, is there a disclosure obligation by the licensee? Seller says, don't tell anybody, I really need to sell my house. Licensees on the horns of the dilemma, what do? I've had people tell me that the stigmatized property statute, 322156, covers it, therefore sellers, listing agents don't have to disclose. Let me deal with that just briefly. Remember, the Stigmatized Property Act says you don't have liability if you fail to disclose there was a suicide, a homicide, somebody with HIV lived in the house, or there's a sex offender in the neighborhood. You have no liability. You're protected. That's what it says. There's absolutely nothing in that statute that says you may not disclose those things. You absolutely can. If you don't, you have legal protection, but you absolutely may make those disclosures. So that's one, is you may do it anyway. And number two, I don't want to defend you in your test case about failing to disclose if, God forbid, seller has it, buyer gets sick and dies. And if you look at 322156A2, you don't have liability if you don't disclose that the property is owner occupied by somebody with HIV, and here's a catch-all, or any other disease that is known to be transmitted through common occupancy of real estate. Based on how new this is, it is the novel coronavirus. I don't think any of us know if this thing can be transmitted by way of common occupancy of real estate. I don't know that you fall in that sort of statute. I don't know that I want to take the chance. I'm going back to let's be kind to one another. If somebody in the transaction has a diagnosis, my take, again, if you want to do something different, talk to your broker, talk to your counsel, but my take, because of these unprecedented times, you should make the disclosure just out of common decency, if nothing else. So that's my take on disclosure. Whether you fit into the statute, I'm not sure. That can go both ways. The statute wasn't addressed with this in mind. Obviously, none of us knew about it at the time. You may fit yourself in there. You may not. And if you don't, and somebody dies, you're going to have a heck of a problem on your hands. So that's what I know about the practice areas. Any more questions about that stuff?
Yes, we have a few.
An hour later, sorry.
So it says, can a seller deny access to an appraiser, home inspector, etc., based on the COVID-19 concerns?
Yeah, that's a very good question. Can a seller deny access to a home inspector appraiser? They're contractually obligated to let those folks in. By not doing so, the sellers are breaching the contract. They're not allowing the buyers to take their inspection and their due diligence and do the look that they're entitled to. So the answer is legally no. From a practical matter, you're going to have a real hard time. Our courthouses are closed just like everybody else. They're open, but it's telephonic. You can't really get a hearing. As a practical matter, if sellers are taking that position, you need to have a frank chat with your buyers and see what they want to do. If they want to move forward, they want to put a pause on. If sellers aren't going to let you in, okay, let's find time out. Let's extend deadlines for 30 days. If that's not going to be the case, your buyers might want to think about moving on. So again, legally, may they do that? May they deny access? No. Are people doing it anyway? Yes. Do you have a remedy for that? No. It's kind of one of those.
Okay. The next question is, do you have suggested ways to protect our liability when we do have an open house in the future?
Yeah, what this looks like, I get that question a lot too. What this looks like going forward, I think all of us are kind of up in the air. I don't know. If there's a vaccine, I think we're back to business as usual. But again, that's my personal opinion. I think we all are going to be more careful. Realtors are huggers. We hug each other a lot. That's probably going to diminish a little bit. At a minimum, we shake hands. With lots of patting on the back. Lots of that stuff's probably going to change. Buyers, sellers shaking hands. Buyers, sellers interacting. The level of cleanliness that you engage in when looking at a house, when showing a house, that sort of thing. I think it's all going to be in the back of our mind. I'll tell you, I've washed my hands so much they're just raw. But if you think about all the things that you touch and all the things that somebody else has touched, and then you're effectively picking up their germs, I think it's going to change us. I think we're going to be, by definition, once Governor Ducey opens us up, we're going to be more, by governmental mandate, more careful. You know, the 6 feet apart sort of thing, and maybe even face covering sort of thing. I think it's going to be different coming out, but we're still up in the air. I don't think any of us knows, and candidly, I don't think Governor Ducey knows.
Okay. And is it okay if we answer some questions that we didn't get to about previous topics?
I will tell you everything I know if you want to ask.
Okay. So this one says, I put my brokerage as my employer. You said agents will probably get denied. Should I go through the hassle and have my application corrected?
Yes. Again, as I understand it and what they're telling us so far, you need to be denied because you're ineligible. You didn't fill it out the right way. I would do it the right way. I would identify you as the employee and the employer, just so you're primed and teed up and ready to go when it's time.
Okay. The next question is, I have a retired tenant on Social Security stating that they are affected by the COVID-19 and can't pay rent. I gave him a 5-day notice. They say that they can't get evicted until July 25th. The lease is the month to month. Can I terminate the lease?
You can terminate, but you can't do anything about it. Again, the evictions are unavailable in light of the governor's orders with respect to COVID-19. So back to where I started, show some grace. You're not going to be able to evict those people. If you go into a court of law, well, you're not even going to get in. You can't file an eviction process as it sits right now, even though they're not paying rent. And one more thing, let me talk about this because I think this is another hot topic. There are many of you out there who own 1, 2, 5, 25 rental properties. Tenants are not paying. Mortgage company still wants your money. Where's the fairness in all of that? I'll tell you, there isn't. There really isn't much. You still owe the mortgage. Your tenant owes you. It's kind of like it's dominoes. They pay, you pay. And if I'm a landlord and can reasonably afford it, I am making the payments to my mortgage every month just because I need to. Doesn't hurt to call the mortgage holder and say, hey, look, I'm having some issues here. Will you give me some forbearance? Will you do this, that, or the other? But the people that own rental properties right now with ornery tenants that are taking advantage are really stuck in a squeeze, and there's no relief for them. They're just stuck in the middle right now.
So I think we have a few questions on Facebook. We're going to answer 2 more questions, but the rest of the questions we'll do our best to answer at a later time. So Brittany, do we have some questions on Facebook?
Yes, we have a couple of questions about the EIDL. And most of them are asking if they can receive unemployment if they apply for that loan.
Same idea, and I talked about this earlier. If you're getting unemployment, you're telling the government you don't have any money, right? If you get an EIDL loan or a PPP loan, you have money. So you're going to have to, for the most part, pick and choose either which program or the timing of which program to go under. For instance, if you get your PPP money now, you pay yourself, and then May 5th through July 31st, you're unemployed, there's no income coming in, then you can be unemployed for that time frame, collect the unemployment benefits. But if you receive money, either federal money through the CARES Act or commissions, while on unemployment, it's going to affect, i.e. reduce or eliminate your benefits.
Okay. And someone is asking if they use the unofficial COVID property showing form, are they at risk for HIPAA issues?
I'm not sure what the unofficial COVID property form is, but I do know what HIPAA is. So let me talk about that. This is unprecedented time. Do we have the absolute right to ask somebody for their medical records? Probably not. HIPAA is going to apply to a medical provider, not to us anyway. But I'm a broker. I'm telling my clients, you need to make the disclosure. You can ask the question right now. Again, different times. Nobody's ever expected or seen this. If somebody has a positive diagnosis, everybody needs to know about it. So I'm encouraging people to ask. HIPAA, in my mind, is a long ways down the road and not particularly relevant to the crisis we're in right now.
Okay, and that was it on Facebook.
All right.
All right. Well, thank you, Rick, for joining us today. Michelle, before we sign off, will you share a few final comments?
Absolutely, absolutely. Rick, thank you so much for all the great information that you shared with our members. I know that everybody sincerely appreciated all the information. So if anyone had a question that you didn't get answered, please send us an email and we'll forward it to the appropriate source to get an answer for you. Remember, if it's a transactional issue, it has to do something with your contract, talk to your broker and manager, who can still call the legal hotline and get an answer for you. Remember to check the Arizona Realtors COVID-19 page on AAR Online. for a lot of resources. And please remember to read your weekly voice, which is delivered to your inbox, email inbox, every Tuesday. So the COVID hotline will stay up as long as we feel like it's needed. The number is on the website, but it's 833-431-INFO. And we will continue at the association to advocate for the industry at all levels of government. And if there's anything else that you can think of that the association can help our members with to get us through this difficult time, please send me a email personally, Michelle Lind at aaronline.com. Again, Rec, thank you. Fabulous job. We really appreciate you and everything that you're doing for the Arizona Realtors. Happy hour begins, so have a great weekend. Stay safe and stay healthy. Thank you so much.